Anyone doing audio check? Morning.
Good morning, Commissioner McKissick.
How are you doing this morning?
Not too bad. Your audio and video sound good. You're good to go.
Thank you.
Sure. Anyone who has not done an audio video check, please turn on their video and raise their hand, please. Morning, Commissioner Duffley.
Good morning.
How are you doing today?
I'm fine. Can you hear me okay?
Yep, audio and video sound good. You're good to go.
Okay, thank you.
Sure.
Hey, John, this is Charlotte, just checking my mic.
Good morning. Yes, your mic is good. Audio and video are good to go.
Okay, thank you.
Sure. Last chance for an audio video check. Please turn on your video and raise your hand.
All right, Joanne, just checking in with you, making sure you're ready to go.
Ready to go when you are.
Okay, perfect. Thank you. All right, everyone, good morning. It's 8:30. We will begin momentarily. Just for purposes of organizing our time today, we will go until 1 o'clock. We will take 2 breaks throughout the course of the morning. I will aim for us to take our first break around 10 o'clock. All right, at this point, let's go on the record, please. Kuka, you may call your witness.
Chair Mitchell, if I might, I'm sorry.
Yes, ma'am, Ms. Downey.
I've got a couple of preliminary matters I'd like to raise.
All right, proceed.
First, Chair Mitchell, regarding witness Roxy McCullers' testimony in requesting that her testimony and exhibits be entered into the record, I inadvertently left out a filing that was made on February 19th correcting an exhibit. And at this time, I would like to move that into the record, and we will provide that to the court reporter and the other parties.
All right, Ms. Downey, hearing no objection to your motion, Ms. McCullers filing made on February 17th, 2020, and this docket will be admitted into evidence.
It was February 19th, but we will file that.
All right, for purposes of the record, her filing made February 19th, 2020 will be admitted into evidence.
And one other thing I wanted to alert the chair to is requested. We don't know the nature of the cross that is going to be provided for Garrett Moore and commission questions, but did want to alert the chair that there's a lot of confidential in their testimony. So just wanted to alert you to that.
All right, thank you, Ms. Downey. I will rely on counsel to alert me when we get to questions that could elicit confidential information from the witnesses. And as a reminder, if and when we get there, we will leave the video conference technology and we will call into a phone line that has been established for this purpose. I believe all parties should have that number at this point in time. So again, I will just rely on counsel to alert me when we get there.
Thank you, Chair Mitchell. That's all I had.
All right.
Chair Mitchell, this is Kiran Mehta, and I have 3 procedural and administrative matters, if I could.
All right, Mr. Mehta, proceed, please.
First off, Chair Mitchell, I did inform both Mr. Page and Ms. Downey about this yesterday evening. Duke Energy Carolinas is the only party that listed cross-examination for Mr. O'Donnell, and on further review, we decided we didn't really need to do that. But obviously, he's here, and Mr. Page, I'm sure, will proceed. Secondly, Chair Mitchell, no party has indicated cross for Eric Leoy, who is a rebuttal witness in the Duke Energy Carolinas case. And unless the commission has any questions for Mr. Leoy, I would ask that he be excused.
Mr. Mehta, as to your request regarding witness Leoy, I would like to consult with my colleagues during our first break, and we will. I will give you a response to your request immediately following that first break.
That's perfectly fine,
Okay.
Chair Mitchell. And the third matter is purely administrative. Yesterday, I think during the examination of Sierra Club witness Wilson, she was asked to take a look at, I believe, Duke DEC Exhibit 3, which was one of the prior orders in this case. When she did, she found that the version that she had didn't have any page numbers, and I just wanted to remind all the parties that I think on September the 2nd, Monica Smith sent out an email indicating that corrected versions of DEC Exhibits 1, 2, and 3, including the page numbers, had been posted to DataSite, and that they should download those corrected versions from DataSite so that we're not fumbling around the next time one of those prior orders is referenced in at least by DEC or any other attorney for that matter. And that's all I had to say.
All right, thank you, Mr. Mehta. And those corrected exhibits were also provided to the commission and commission staff as well. So thank you, Mr. Mehta, for that housekeeping notice. All right, any additional preliminary matters before we begin?
Chair Mitchell, Kamal Robinson, just one quick clarification. So the parties have not received the confidential phone line number yet, receiving it shortly. So for any parties that did not receive it or thought they did not receive it, it just hasn't come out yet. And as a matter of fact, I think I just saw an email that just shared it. So for those parties to be aware of that.
All right, thank you, Mr. Robinson. All right, any additional matters?
Madam Chairman, this is Bob Page. I have one additional matter in view of the date today. I wonder if it would be appropriate for the record to show that we paused briefly to remember the events of 19 years ago, the horror and the heroism and the shadow that still exists over our country. But I may be a cockeyed optimist. I just happen to believe that as Americans, there's a lot more that unites us than temporarily divides us. And that maybe we should bear that in mind today as we struggle through the events that confront us.
All right. Thank you, Mr. Page, for that reminder. It is appreciated.
Mr. O'Donnell, are you there?
Yes, I'm here.
All right, Mr. O'Donnell, let's go ahead and get you under oath. Would you raise your right hand, please, sir? You affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth.
I do.
All right, Mr. Page, you may proceed.
Thank you, Madam Chair. Mr. O'Donnell, would you identify yourself for the record by giving us your name, the name of your business, and your business address?
Kevin O'Donnell. I'm a financial analyst with Nova Energy Consultants, 1350 Southeast Maynard Road, Suite 101, Cary, North Carolina.
Mr. O'Donnell, with the chair's permission, I'm going to ask you a series of leading questions to try to get these qualifications and the housekeeping matters out of the way as quickly as possible. This is actually your third appearance as a witness in this case, is it not?
Yes, it is.
And previously you testified twice during the consolidated phase of these hearings, did you not?
Yes, I did.
And the first such occasion you presented the portions of your testimony dealing with the cost of capital issues, including capital structure and rate of return and return on equity. Is that correct?
Yes, that's correct.
And in the second phase, most recent phase of your testimony, you presented those portions of your testimony which discuss the GIP or grid improvement or grid modernization. Is that correct?
Yes, that's correct.
And the purpose of your testimony today is to present the other two topics discussed in your testimony, which are first, coal ash, cost of coal ash cleanup and cost recovery of those costs. And the second issue being cost of service and rate design. Is that correct?
Yes, that's correct.
All right, Mr. O'Donnell, the testimony you are sponsoring in this case is the updated testimony which was filed on or about April 23rd, 2020, consisting of some 132 pages of written question and answer narrative, an Appendix A, and exhibits entitled KW01 through KW08. Is that correct?
Yes, that's correct.
Are there any further updates or changes or corrections that should be made to either the testimony narrative or the appendix or the exhibits at this time?
No, there are not.
If I were to ask you the same questions that appear in the pre-filed testimony as filed in an updated version on April 23rd, would your answers today be the same as when pre-filed?
Yes.
Madam Chair, we request that Mr. O'Connell's pre-filed testimony be copied into the record as though given orally from the stand, and that his appendix and exhibits be identified as pre-filed.
All right, Mr. Page, the motion is allowed.
Mr. O'Donnell, did you also prepare and cause to be filed in this case with the commission and the parties a summary of the testimony you're about to present today?
Yes, I did.
And are there any changes that need to be made to the summary?
No.
Madam Chair, we request that Mr. O'Donnell's summary of the issues he is discussing today be copied into the record as to given orally. And with that, Mr. O'Donnell is available for our full cross-examination by the commission since Duke has waived.
All right, Mr. Page, your motion is allowed. We're getting a lot of feedback from the line this morning. I believe it's when you and Mr. O'Donnell are both unmuted. So I'd ask that you all just keep your lines muted until you need to speak. All right, so the witness is available for questions. The only party who has indicated cross-examination or reserved cross-examination time for the witness is is Duke. We've heard that Duke has no questions for the witness. Any other cross-examination for the witness?
Yes, Chair. Alan Jenkins.
All right, Mr. Jenkins, you may proceed.
Thank you, Mr. O'Donnell. Alan Jenkins for the Commercial Group. How are you today?
I'm good, sir. How are you?
Good. I had some questions yesterday that I thought you might shed some light on. You've been involved with the OPT issues for many years, haven't you?
Yes, many is kind.
Now, do you recall the process where the current OPT structure was negotiated between parties and finally approved by the commission several cases ago?
I'll be honest with you, Mr. Jenkins, I don't remember the parties negotiating the OPT. I do remember it being approved, but I don't, put it to you this way, I wasn't part of any negotiating process, or at least I can't remember it.
But you gave input over the years on how to structure an OPT program, is that right?
Yeah, I think that's probably correct. I mean, I have definitely submitted testimony in terms of rate design and cost of service study before this commission. Specific to OPT, I don't remember. I'm sorry.
Okay, no problem. Have you heard any discussion about a potential comprehensive rate design process?
Yes, I have.
Now, would you say of all the rate schedules of DEC that the OPT has had more review than perhaps any other?
I couldn't testify to that. It may make logical sense, but I really don't know the details of whatever else has been examined. I'm sorry.
Fair enough. Would you expect in the upcoming process that your client would agree to, let's say, an SWPA class cost of service study being implemented?
No. Can I explain my reason why?
Sure.
And I think this commission knows that I've done a lot of wholesale power work in my day, done about 30 wholesale power deals around the Carolinas. And in wholesale power markets, the fixed costs are always allocated on peak demand. Variable costs are always, excuse me, let me back up. Peak cost, fixed costs are always priced, not allocated, but they always priced on demand. Typically peak, well, always peak demand. Variable costs are always priced on energy. There is no allocations. They are always priced in that way. I think if the theory of regulation is to mimic what is available in the open competitive markets, then the price signals we ought to be sending ought to be based on peak and not summer, winter peak and average. And I have a tremendous amount of respect and admiration for Mr. McLaughlin. I heard his discussion yesterday. I just don't know too many, if any, industrials that have the ability to shut down their factories at time of the system peak. I mean, I just don't see it. On top of that, on retail, you're not given load signals. It's not like Duke sends out a load signal to everyone and says, hey, shut down. On the wholesale side, yeah, you can do that. You can run a diesel generator in your back and clip the peak because wholesale has Quinston Peak in Duke's formula regulated rates. You don't have that on the retail side. So that's a long answer to say, Mr. Jenkins, that I do not believe that my clients would welcome the summer winter peak and average, because it is not market driven, at least not in the markets that I see, in the competitive markets that I see here in the Carolinas.
Do you have any opinion as to whether a comprehensive rate design review process, as is being discussed, would resolve all these issues ahead of the next DEC rate case?
I think it's going to be a tall order. From what I understand, Duke's going to be coming in for rate cases on a very frequent basis. I can understand the worthwhile, the need for the process. I would just argue again that if what we're looking for is to lower rates for our respective clients, then we perhaps ought to look at market pricing, and we ought to go towards market pricing, because that's how you're going to lower rates for our clients, the consumers. I can take you to several places in the Carolinas where market prices have lowered rates for residential customers a whole lot more than what we could be discussing in pricing reform, such as the minimum system study.
Thank you. And one further question. Do you have any opinion as to whether rate design suggestions that you've made in this case, or other parties have made in this case, for say adjustments to the OPT, should be postponed until there's a comprehensive rate review process done?
I would hope not. The arguments that I've made here in this case have been made previously and have not been addressed by Duke. So what I'm saying here is not new to Duke. They've seen it before, and we haven't received any traction on it. In terms of waiting until the next rate case, as you well know, Mr. Jenkins, and I think you pointed out yesterday regarding loss of pennies, we have several manufacturers around the state that may not come back into play, or may not come back into business. And these rate increases, and I indicate this in my testimony, between grid mod, coal ash, and coal to gas, we're looking at pretty sizable rate hikes. That's going to really harm manufacturing in North Carolina, which was the backbone of the state's economy, and it's obviously going to harm your customers as well. So I would argue that we really can't wait too much longer. A lot of our folks are not going to be coming back.
Thank you. Nothing further.
All right, any additional cross-examination for the witness? All right, Mr. Page, any redirect for your witness?
Very shortly, Madam Chair, thank you. Mr. O'Donnell, I believe you stated in response to one of Mr. Jenkins' questions that you did hear the discussions yesterday afternoon by the public staff panel, including Mr. McClawhorn and Mr. Floyd. Is that correct?
Yes, I did.
And did you hear the portion where, if I understood his testimony correctly, Mr. Floyd was saying that the landscape over the last 40, 50 years in the electric business has changed, and there are all these new things coming online with diversified generation and smart metering and smart grids and this and that and the other thing. And all of that is proposed, as I understand it, to be taken up in these new rate studies. My question to you is, are you aware of anything in those proposed new rate studies that would change the principle that has been around since before Professor Bonbright's book, that what you do in a cost of service study is you allocate costs to the group of customers who are imposing those costs on the system. Do you see that changing?
I would hope not, because again, that is not reflective of what happens in competitive markets. That's not what happens outside of the world of regulation.
Thank you, Mr. O'Donnell. That's all I have.
All right, questions from commissioners, beginning with Commissioner Brown-Bland.
I don't have any questions.
All right, Commissioner Gray.
No questions.
All right, Commissioner Clodfelter.
Nothing from me this morning. Thank you.
All right, Commissioner Duffley.
No questions.
Commissioner Hughes.
No questions.
All right, and Commissioner McKissick.
No questions.
All right, Mr. O'Donnell, you are off the hook.
Madam Chair, we'd like to move that Mr. O'Donnell's appendix and exhibits be admitted into the record at this time, and that Mr. O'Donnell be excused from further participation in the Duke Carolinas case.
All right, Mr. Page, your motion is allowed. Thank you for your time this morning, Mr. O'Donnell.
Thank you.
All right, Ms. Downey, we return to the public staff. You may call your witnesses.
Good morning. This is Megan Yost with the public staff. The public staff calls Bernie Garrett and Vance Moore.
All right, good morning, Ms. Yost. And let me see if I can find your witnesses. There's Mr. Moore. Mr. Garrett, I need your video turned on, please. All right, Mr. Garrett, still cannot see you.
Give me 1 second. I may try to assist. It's
Oh, there he is. There he is. All right, gentlemen, would you please raise your right hands? Do you affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do. Yes, I do.
All right, Ms. Yost, you may proceed.
Thank you. I'll begin with Mr. Moore. Mr. Moore, please state your name and business address for the record.
My name is Vance Moore. My business address is 206 High House Road, Cary, North Carolina.
By whom are you employed and in what capacity?
I am employed by Garrett and Moore Incorporated, and I am the president.
Did you cause to be filed in this docket on February 18th, 2020, direct testimony consisting of 25 pages and 7 exhibits, 6 of which were marked confidential?
I did.
Do you have any corrections to that testimony?
I do not.
If you were asked the same questions today, would your answers be the same?
They would.
And did you prepare a summary of your testimony?
I did.
Chair Mitchell, at this time, I would move that Mr. Moore's pre-filed direct testimony and summary be copied into the record as if given orally from the stand, and that his 7 exhibits be marked for identification as pre-marked in the filing.
All right, the witness's testimony and summary of that testimony will be copied into the record as if given orally from the stand. The exhibits to that pre-filed testimony will be marked for identification as they were when pre-filed.
Thank you. Mr. Garrett, please state your name and business address for the record.
My name is Bernie Garrett. My business address is 206 High House Road, Suite 259, Cary, North Carolina. I'm the Secretary Treasurer of Garrett and Moore Incorporated.
Thank you. Did you cause to be filed in this docket on February 18th, 2020, direct testimony consisting of 50 pages and 21 exhibits, 12 of which were marked confidential?
Yes, I did.
Do you have any corrections to that testimony?
No, I do not.
If you were asked the same questions today, would your answers be the same?
Yes, they would.
And Mr. Garrett, did you prepare a summary of your testimony?
Yes, I did.
Chair Mitchell, at this time, I move that Mr. Garrett's pre-filed direct testimony and summary be copied into the record as if given orally from the stand, and that his 21 exhibits be marked for identification as pre-marked in the filing.
All right, Mr. Garrett's pre-filed testimony and summary of that pre-filed testimony will be copied into the record as if given orally from the stand. The exhibits to Mr. Garrett's pre-filed testimony will be marked for identification as they were when pre-filed.
Thank you. The witnesses are available for cross-examination.
All right, we will begin with the Attorney General's office.
No questions, Chair Mitchell.
All right, thank you, Ms. Townsend. All right, Duke.
Thank you, Chair Mitchell. This is Brandon Marzo on behalf of Duke Energy Carolinas. I do have some questions for the witnesses this morning. We will get into confidential, Chair Mitchell, at some point. What I've tried to do, Mr. Garrett, Mr. Moore, as well as Chair Mitchell, is to organize my questions such that we could avoid that. At the point in time we cannot avoid it, I've tried to consolidate all that to one exercise so that we don't have to jump on and off the phone.
All right, thank you, Mr. Marzo. Just make sure you alert me when we get to that point in time.
Okay, thank you, Chair Mitchell. Good morning, Mr. Garrett, Mr. Moore.
Good morning.
Good morning.
I'm going to start off with some general questions to both of you, and then I'm going to ask some specific questions about your recommendations in this case, starting with Mr. Garrett. In regards to the general questions that I'd like to ask to both of you, my first question is essentially, would you agree with me that reasonableness and prudence is decided on a case-by-case basis and must consider multiple factors?
Yes, I would agree with that.
I would also agree.
Thank you, Mr. Moore. Thank you, Mr. Garrett. Would you also agree that the lower cost options may not always be the reasonable and prudent decision?
Depending on specific circumstances, as you mentioned, in fact, and numerous factors, yes, that could be the case.
I would agree that cost is just one of the factors.
Okay. Thank you, gentlemen. And finally, would you agree that alternative proposed actions must be feasible in order to be truly alternatives?
Yes, I have no problem with that statement.
I would agree that it must be a practical alternative.
Thank you, gentlemen. I think my questions now will be directed primarily to you, Mr. Garrett, for this first part in reference to your Dan River recommendation. And it's my understanding from your testimony that you're recommending that the commission disallow costs which you contend amount to premium rates for ash excavation and disposal at Dan River. Is that correct?
Yes, sir, that's correct.
And my understanding is you question the company's termination of Parsons and transition to Transash. Is that correct?
Yes, I did. That's part of the basis for my recommended disallowances.
Can we agree that at the time of Parsons' termination on the project, Parsons was experiencing significant difficulty?
I believe that Parsons, as far as their performance on the contract, was meeting their contractual obligations up until the time of around June of 2018, when they first fell behind their cumulative production schedule.
Okay, could you, if you would, please turn to DEC Carolinas Cross Exhibit 34? Do you have that? I'll give you a second to grab that.
Cross Exhibit 34.
And while you're looking for that, the document I've referred Mr. Garrett to is Duke Energy's court-appointed monitor bi-monthly update, which was submitted to the United States District Court on September 14th, 2018. Chair Mitchell,
yes, sir, I have that up now.
Thank you, Mr. Garrett. Chair Mitchell, I'd like to mark that as Garrett and Moore, DEC Garrett and Moore Cross Exhibit 1.
All right, the document will be marked DEC, Garrett and Moore, cross-examination, exhibit number 1.
Okay, and I think, Mr. Garrett, you've seen this document before, correct?
Yes, I have reviewed this.
Okay, and could you turn to page 4 of the document, please?
Yes, sir.
And would you mind reading from the top paragraph that begins, "While these problems," would you mind reading the first 2 sentences of that paragraph for me? And then I'm going to ask you some questions about that.
While these problems originated with the contractor, Duke personnel acknowledged the need for increased oversight and were working to learn from this mistake while sharing successful strategies between other ash sites. The root cause, continue?
Yeah, continue. Yes, yes, sir.
The root cause appears to be ineffectiveness of the contractor's use of well point dewatering, the use of groundwater pumps connected to chimneys in the ash basins to suck water out, which led to the landfilling of overly moist ash and the cascade of other landfill erosion problems.
Thank you, Mr. Garrett. Now, are you aware that the contractor being referenced here is Parsons?
Yes, sir.
And am I correct, from the last sentence of this paragraph, the monitor has asked to be kept informed as to the progress? Is that correct?
Yes, that's correct.
Now, I'm sorry, go ahead, Mr. Garrett. I mean, interrupt.
I see that in the last in the paragraph, yes.
And can we agree that Dan River was a high priority site with an August 1st, 2019 excavation requirement in CAMA?
Yes, sir.
And are you aware that under the Parsons contract, Parsons was required to submit to Duke Energy recovery plans if key milestones were delayed or reasonably forecasted to be delayed?
I am familiar with the fact that Parsons submitted recovery plans at Duke Energy's request. Yes.
Okay, and recovery, to that point, recovery plans were submitted to Duke when the contractor had fallen behind, correct?
I'm aware of those, yes.
Okay. And so are you aware that from the period of March 16, 2018 to August 16, 2018, Parsons submitted 6 recovery plans?
I don't recall the exact number.
Okay, you take
I
the
do know
subject to
they
check.
submitted recovery plans, yes.
Okay. And those recovery plans were needed because of key delays in schedule in a 5-month period. Are you aware of that?
The delays in the schedule occurred prior to this 5-month period you're discussing. The delays are well documented in the record. And many of them, as far as the longest delays, most of those occurred prior to Parsons beginning work on the project.
Okay, Mr. Gabbard, let me understand this. Do you disagree that Parsons fell behind and had to submit 6 recovery plans?
I believe that Parsons was behind schedule as far as you turn to my exhibit 13. On page 39 of this exhibit, this is the Maximo purchase order number 5067043.
Excuse me,
And I think I just want to be careful here. And once again, Ms. Garrett, I want to give you an opportunity to respond, but are you going to read me something or are you just going to point me to something?
I'm going to point to the,
Because this
key
document is still
milestones.
confidential. Yeah.
Yeah, it is the key milestone schedule, which provides the month by month cubic yards that are in Parsons' contract. I don't believe that information would be confidential. There's no dollar amounts associated with it.
It is part of the contract that is confidential, but to the extent you'd like to reference back to that, we will be going off to the phone line.
Well, I can just note that in reference to this schedule, Parsons, based on my records, first fell behind in June of 2018.
Okay, thank you, Mr. Garrett. And I guess one of the questions I had about your review of Parsons and its interaction on the project, it's my understanding that you did not review any of the recovery plans prior to coming to your recommendation in this case. Is that correct?
No, I believe I did. We did have recovery plans submitted during the data responses.
Yeah, and they were submitted, for example, in response to data request 231-10, the recovery plans were submitted. And that data request was issued after Ms. Bendarsic responded to your testimony and rebuttal. Is that your
Thank you
understanding?
for clarifying that.
Okay.
And I would say that, I have a significant amount of experience preparing bid documents, construction documents, and performing construction administration on large scale construction projects such as this. And, the fact of the matter is, when a contractor loses a day of work due to adverse weather conditions, it's nearly impossible to make that day up. Once you have lost a day of work, the only real relief for a contractor is to have a day of extension on the contract. So recovery plans, while they were required in the contract to be submitted, there's only so much a contractor can do once they've fallen behind due to adverse weather conditions.
Okay, Mr. Garrett, I understand you're referring to adverse weather conditions, but can we agree that on any complex project, there are going to be any number of factors that might cause or challenge the schedule to a project, correct?
Yes, sir.
Okay, and weather may be one of those challenges, correct?
Well, weather is I would say also it interrelates with weather, but the ability to dewater an ash pond in order to allow the contractor to maintain production is probably one of the most critical aspects. It interrelates with adverse weather. And based on my reading of Parsons' contract, Duke Energy was responsible for the discharge of all wastewaters from the Dan River site.
Okay, and you understand that Duke Energy was also responsible for oversight of that contractor, correct?
They were responsible for maintaining adequate discharge so that the contractor could meet his production schedules, yes.
Mr. Garrett, that wasn't my question. What I asked you was, you understand that Duke Energy Carolinas, as the party that was overseeing the contractor, was also responsible in assessing the contractor's performance, correct?
Yes, they were overseeing the contract and the contractor simultaneously, yes, sir.
Okay, and for example, you could have a number of things that challenge a project. Weather could be a challenge. There could be a dewatering challenge, as you point out. But there could also be a contractor who's not performing. That's a challenge. And am I correct that you would expect someone who is overseeing that type of project to address all of those challenges?
Within the, as long as those challenges are within their control, Yes.
Okay, and clearly, whether or not you maintain a contractor on a site, on a project, is within the control of Duke Energy Carolinas in this case, correct?
Would you repeat that? I'm sorry.
Sure. Clearly, whether or not you continue with a contractor is well within the purview of the company as it pertains to these projects, correct?
Yes, ultimately, that's their decision whether to continue with a contractor, yes.
Now, we talked about the recovery plans that weren't reviewed until after you had submitted your recommendation, but there were also sequence excavation plans that were submitted to you after you had submitted your recommendation in this case, correct?
Are you talking about sequence excavation plans submitted by Parsons?
Exactly. Those weren't requested by you until after Ms. Bendarsic filed her testimony in this case, correct?
Yes.
Okay. Now, Duke Energy terminated Parsons on October 12th, 2018. Is that your understanding?
Yes.
Okay. And I know you said you didn't look closely at the recovery plans, but is it your understanding that the sixth recovery plan of the last one, which was the sixth one submitted by Parsons, was submitted about 12 months prior to the CAMA deadline?
Yes, it would have been right around September. Yes.
Now, in your testimony, you suggest that DE Carolina should have sought an extension under CAMA. Is that correct?
I believe based on the adverse weather conditions almost alone, there was justification to go to DEQ and request an extension. I believe that was a feasible option for them at the time when they were making the decision to change contractors, yes.
Okay, and specifically on page 50 of your testimony, you state that requesting a variance from DEQ would have taken little effort.
Little effort as in relative to the amounts that were spent to recover Transash's schedule, yes.
Okay, let's talk about what would have been little effort. If you would, for me, would you turn to DEC Cross Exhibit 38?
Uh, 38.
Yeah.
Could you tell me what that is?
Sure, it's the variance authority regulations.
Okay, is that section 130A-309-215?
Yes, sir.
Okay, yes, sir. I have that in front of me now.
And just be sure, Mr. Gary, you're not getting an echo from me, are you?
I can hear you fine.
Okay, just want to be sure. Now, this is a copy of the variance statute from CAMA, which is the section of CAMA that addresses the deadline variance requirements. Chair Mitchell, I would just ask the commission to take notice of the statute. I don't think we need to mark it as an exhibit.
All right, the commission will take judicial notice of the statute.
Now, although you're not a lawyer, you understand that the statute provides no assurance or guarantee that an extension request will be granted, correct?
Yes, there would be no guarantee.
And in fact, the decision to grant or deny variance requests is solely within DEQ's discretion, correct?
The decision is made by DEQ, yes.
Okay, and there are some key elements in the statute in terms of what is required to be shown in order to get a variance. And I want to point you to specifically section A1. Do you see that?
Yes.
Okay, and right around the middle, Mr. Garrett, of A1, there is a sentence that begins with the words "the owner," and I'm just going to, for efficiency, read that for you, and you tell me if I read that correctly. It says, "The owner of the impoundment shall also provide detailed information that demonstrates the owner has substantially complied with all other requirements and deadlines established by this part, look 2II. The owner has made good faith efforts to comply with the applicable deadline for closure of the impoundment, 3, the compliance with the deadline cannot be achieved by application of best available technology found to be economically reasonable at the time and would produce serious hardships without equal or greater benefits to the public. Did I read that correctly?
Yes, sir. And I believe that based on my review, Duke Energy could have checked all three of those boxes unless they themselves thought they had not made good faith efforts to comply with the applicable deadline.
Okay, so let's talk about that because the first element is a good faith element. And are you aware that as of September 2018, Duke believed that it could replace Parsons and complete the excavation work at Dan River?
I know that Transash provided a schedule and an ash production, monthly ash production rate to Duke Energy that Duke Energy relied on in making the decision to switch to Transash. And I do know that Transash themselves was unable to meet that production schedule that they submitted to Duke Energy. That was the basis for the decision to switch in October.
But what we both know, I believe you know this, Mr. Garrett, is that switching to Transash, Duke did complete the Dan River excavation within the CAMA deadline, correct?
Not on the basis of Transash's proposal to them, only after incurring the costs that I have documented in my testimony, which were above and beyond costs that were the basis of their decision to switch to Transash.
And I appreciate that, Mr. Garrett, but I do want to understand that you agree with my question. So I want to make sure we don't have a disagreement on that. Do we agree that Duke did replace Parsons with Transash and was able to complete the project within the CAMA deadline?
Yes, only with incurring the costs that I have recommended for disallowance. Yes.
Okay, you talked about there being some additional costs related to Transash, but are you aware that even switching to Transash, the project came under the forecasted contingency amount?
Well, and I believe that Transash had the benefit of Duke Energy seeking increases in the wastewater discharges that they were allowed and permitted to discharge. Parsons was not a beneficiary of that relief. So in my opinion, Transash's ability to meet the schedule was largely helped by the fact that Duke Energy sought to increase the amount of wastewater that they could discharge to the city of Eden. They also increased the amount of discharge by implementing outfall 002 and a treatment system, which went into effect early of 2019.
So let me understand this, Mr. Garrett. Are you suggesting that Duke Energy did not do things to assist Parsons to successfully complete the project?
I believe that Parsons' performance on the project was significantly limited by the permitted discharges to the city of Eden, which Duke sought to increase from 0.3 MGD to 0.6 MGD in October of 2018, while simultaneously submitting to DEQ a request to utilize outfall 002, which gave them the ability to discharge 1.5 MGD of interstitial water.
And Mr. Garrett, I understand that you're focused on the dewatering aspect of the project. And I think we talked about earlier, there's often several challenges that can face a project like this. And one of the challenges can be a contractor that's not performing up to the level that's expected. And is it your opinion that in that occasion, you'd expect Duke to address each and every challenge, not just one challenge, but to address all the challenges, correct?
Yes, and I believe the most significant challenge facing Parsons was wet ash. And I believe Ms. Bignarczyk even discussed this in her testimony about how you can't excavate and you certainly can't landfill and meet compaction requirements on wet ash. The ash must be dried. And if you're limited in the quantity of water that you can discharge from the site, you can't achieve adequate dewatering to maintain any type of production schedule.
Now, have you reviewed public staff data request 193-1?
Could you just describe that?
Sure, it's a non-confidential data request, and I was gonna ask you some questions, and I want to make sure you understand what I'm asking you is not confidential. It may be part of a confidential document, but this particular request was not. So let me ask you a couple of questions, and feel free to respond to me on what I'm asking you, because it's included within the data request. That's not confidential. Now, you mentioned earlier that you felt like Duke was not assisting Parsons, may have been assisting TransAsh. Are you aware that Duke held calls with senior management as early as May of 2018 with Parsons senior management to discuss issues with their work at the site?
Well, May of 2018, May of 2018 is the first date that Parsons began to fall behind schedule. Yeah, so I believe it would have been appropriate to have conversations with them at the time.
And are you aware that the company worked with Parsons and allowed their leadership team to visit active excavation sites such as Sutton, where TransAsh was excavating, to see how excavation was going well and to take those lessons learned?
Yes, sir. And I'd say that the chief difference between Dan River and Sutton was the quantity of water that they could dewater and discharge from the plant. They were not limited at Sutton. The only limitation at Sutton was a specific flow of the interstitial water of around 1.5 to 2 million gallons a day. So that was a primary difference between the two sites.
Okay, and I appreciate that, but are you aware that Duke also brought in teams from Sutton and River Bend to assist in giving lessons learned to Parsons at the Dan River site?
Yes, but I don't know that they, showed them how to overcome handling wet ash.
And are you aware that the company helped Parsons with both the development of a stockpile management plan and a landfill weather resistant plan?
Well, yes, I'm familiar with those plans. Yes.
Okay. Now, have you reviewed the March 26, 2019 decision granting in part variance with conditions?
Would you repeat that?
Yeah, it's DEC Exhibit 35. Cross Exhibit 35, Mr. Garrett.
Yes, I have read this. I believe I reviewed this during my preparation of my testimony.
Okay, and it's the March 26, 2019 decision granting in part variance with conditions, correct?
Yes.
Okay, and this is in reference to Sutton, which you utilize in your testimony as an example of when Duke has sought the variance and gotten the variance, correct?
Yes, it's the only variance that I'm aware of that Duke has sought. Yes.
And I assumed from your statements in your pre-filed testimony that you believe, in part at least, that this took little effort to seek and receive this extension.
I don't know that I would characterize it as little effort unless you are comparing it in terms of cost to the company. This was an administrative exercise, gathering documents, personnel that had to work on this. But in contrast to dollar amounts in a construction project, yes, little effort.
Okay, and I'm just using your language, Mr. Garrett.
Yes.
So however you meant little effort is what I'm using is my clarification as to what I believe you were trying to say in your testimony.
Yes, no, it was an administrative exercise that took time to put together. I don't dispute that.
Okay, and you called it an administrative exercise, but let's look at some of the details and see how much is administrative and potentially how much is not.
Okay.
Would you look at page 4 for me, paragraph 7 in particular. And this paragraph has subparagraph 7C, and this is the department's conclusions regarding certain steps and actions that Duke Energy had taken. And would you for a minute read 7C for me?
Yes, do you like read it out loud?
Oh, no, you don't. You don't need to read out
okay.
loud. It's just to save
Okay.
you the time of having to do that.
Sure.
You just let me know when you're finished with that, and I have a couple questions I want to ask you about it. Chair Mitchell, for the record, I would like to mark Exhibit 35, DEC GAM Cross Exhibit, I believe 2.
Okay, yes, I have, I've read it.
All right, Mr. Marzo, the document will be marked DEC Garrett and Moore cross-examination exhibit number 2.
Thank you, Chair Mitchell. Okay, so in making the application, if I look at 7C, in making the application for variance, Mr. Garrett, DE Progress had to make a variety of showing, such as excavating an average rate of 150,000 tons per month of ash, expediting completion of that landfill, expanding dredging operations, adding a 3rd conveyor, simultaneously operating 3 dredges, and taking various additional measures. Is that correct?
That's what paragraph 7C states, yes.
Okay, and that's more than administrative, correct?
That's documenting efforts that were made at the project site.
Okay, and those were efforts, can we agree, efforts that were necessary to justify asking for a variance?
I believe that those were actions taken at the Sutton plant during the course of the project.
Now, are you aware that one of the additional measures that DE Progress took was moving to a 24-hour, 7-day-a-week schedule?
Well, that's not exactly correct. Are you talking about Sutton plant?
I'm talking about the application for Sutton's variance. Are you aware in order before making this request, they went to a 24-hour, 7-day-a-week schedule?
What I recall in this document is that they operated a double shift on the dredge. Sutton had very deep ash, which required deep excavations, which could only be accomplished by a dredge. And they went to, I believe, 2 10-hour shifts on operation of the dredge. But I do not believe they went to any 24/7 hauling of ash from the ash basin to the landfill. If you could point that out in here, that would be great.
Well, if you disagree, Ms. Bedarsic will be here to take that up later. I don't have a document to show you, but I'm just asking, are you aware?
It would be in this document, correct?
So you disagree that they went to a 24-hour a day, 7-day-a-week
I have
schedule?
not seen that documented.
Okay.
Yeah.
Are you
I know
aware
they did the dredge work on a double shift.
Okay, and I understand that you disagree with that, Mr. Garrett, and we can definitely bring clarity to that in our rebuttal. Are you aware that DE Progress also had to provide detailed information regarding technology that DE Progress was deploying to overcome delays, as well as additional technology that had to be evaluated?
Yes, but there's really no specifics provided on the technology that I see in paragraph D, but I'm sure that, they presented everything that they had used on the site to try and meet the deadline, which would be appropriate.
Okay, and it's your perspective that that takes little effort to do that?
To write paragraph C or D?
Well, maybe understand your too little effort, because maybe there's just my confusion about how you're using that. Are you simply saying it takes a little effort to write up a variance application, or are you saying it takes a little effort to actually justify one?
No, I believe that when I say little effort, I'm not talking about all the work that Duke did at the project site to try and achieve the deadline. When I refer to little effort, I'm talking about preparing the request. the paperwork required to request an extension. And as far as its applicability to Dan River, there's many documents in the record that detail delays that Duke had to overcome at Dan River, many of them which were not of their making, which all would have been efforts made, technology used to meet the CAMA deadline.
Okay, and what we do know, Mr. Garrett, is that by changing out the contractor, Duke did make the deadline that CAMA prescribes, correct?
They did, yes.
Okay. And so, and maybe I can probably sum up some of my clarification questions now. I think I have a better understanding of your little effort. You do agree then that in terms of meeting the requirements in the statute to request a variance takes significant effort, correct?
I believe that Duke undertook extraordinary efforts at Dan River with everything they had to accomplish in order to meet the CAMA deadline. But I believe that preparing a document to submit to DEQ would have been a relatively straightforward step for them to take in September when they were contemplating the change of contractors.
And you would agree that would only be an appropriate step if Duke believed in good faith it could substantiate what's required by the statute in that request.
I believe if Duke would have had the total cost in front of them that they ended up paying to Transash to meet the deadline, that they would have been more compelled to seek a variance.
And as we mentioned earlier, you understand that the total cost expended for the project came in under the contingency amount for the project, correct?
Yes, contingencies. That still does not, in my mind, make these costs acceptable.
Now, your final suggestion is that D Carolinas continue to meet the deadline by continuing excavation based on the negotiated rates with Parsons as the contractor. Now, you understand that, as we talked before, Parsons had significant issues making schedule during the time period this decision would be made, correct?
I believe if Duke had the ability to discharge 1.5 million gallons per day the whole time that Parsons was on the project, their performance would have been significantly more acceptable.
And that's not my question, Mr. Garrett. What I'm asking you is that 12 months prior to the CAMA deadline, your alternative is that Duke should wait it out with Parsons, who's not been performing up to schedule, and just pray that they can make the CAMA deadline, correct?
I think as far as meeting the deadline with Parsons, I'm not convinced that that was not a feasible option, considering the fact that they were providing relief through their additional dewatering.
And I assume, and you talk about that being a feasible option to make the CAMA deadline, you are assuming that that would have to be done with some level of overtime, as well as some conditioning requirements for the ash, correct?
Not really, based on if you look at Parsons' overall production rates. I believe if you extrapolate those out, it's close to the deadline, but based on their historic performance, had they continued to achieve what they achieved prior to that, they would have been close to ending at the deadline.
I'm sorry, Mr. Garrett, please finish.
I don't believe they would have finished by May of 2019, but it would have been feasible, I believe.
And you think it would have been reasonable and prudent facing a compliance deadline that Duke Energy just roll the dice and hope that Parsons can improve his performance?
I would have sought a variance as a backup plan.
Okay, thank you, Mr. Garrett. I'm going to move on to Mr. Moore. Once again, Mr. Moore, I'm going to ask you some questions. They hopefully are not intended to elicit any confidential information. We will have a confidential part of the call, so we may transition during this line to that, and I'll let the chair know when that happens. Is that fine with you, Mr. Moore?
Yes, sir.
Okay, thank you. Now, if I understand your testimony correctly, you're recommending that the commission disallow recovery of certain construction costs at Duke Energy Progress, H.H. Flee, Cape Fear's beneficiation plan, and for this case, Buck's beneficiation plan. Is that correct?
Specifically in this case, we're discussing Buck. If you want to go to the Duke Energy Progress, we are talking about the other two beneficiation plans.
Yeah, I mean, the recommendation is your disallowance recommendation is generally the same for all of them, which is why I mentioned all of them. Is that correct?
That is correct.
Okay. Now we're only going to talk about Buck here, but I just wanted to clarify that the recommendation you're making here is generally the same recommendation in the Progress case. Now you're familiar with CAMA's beneficiation requirements, correct?
That is correct.
And your testimony does not take issue with Duke Energy's selection of Buck as a beneficiation site, correct?
Correct.
Or any of the beneficiation sites for that matter, in this case, correct? Okay.
Correct.
And you agree that the company's decision to award the engineering contract to CEFA was reasonable and prudent. Is that correct?
That is correct.
Okay. And my understanding from your testimony is you do not take issue with any of the change orders issued by CEFA or Zachary, correct?
Not in my testimony, correct.
Okay. And your sole concern is, from what I can garner, is that you believe the estimate of EPC project cost included in Zachary's master contract was higher than the construction screening estimate provided in CEFA's response to the company's request for information. Is that a fair recitation of your position?
Yes, sir.
Okay. Now, CEFA's RFI response included in part the EPC cost information from the Wynyard Star facility in South Carolina. Is that correct?
I disagree with that completely. I think that their response was based upon their experience of building a similar plant, but their cost was not simply saying this is what the CEFA Wynyard plant cost. What they presented in their RFI response was, based on our experience building similar technologies, we believe a plant meeting CAMA requirements would cost in the amount that they presented. So I do not believe it is saying this is what the Wynyard plant costs.
Okay, but we can agree, Mr. Moore, that estimate had to be based upon something, correct?
I believe it's based upon building a technology to meet the CAMA requirements.
And what we know is at the time that the RFI was provided to CEFA, there were no site-specific details provided to CEFA in order to respond and make its own estimate to site-specific specification. Is that correct?
I believe that they did not identify the specific sites. Correct.
Okay. And at the time of the RFI, the company had not determined the location for the beneficiation site or provide any sort of design detailed engineering upon which to base a cost estimate, correct?
That is correct.
Okay, and then that's
I think that needs to be clarified as the importance of that from the standpoint of, you know, we use a term sometimes of you have a plant site that has certain, you know, a building with certain components inside of that building. And are we talking about how the components would be different in each one based on the site? Or are we talking about how the foundation for the floor would be different for the building based upon the site? So I think it's important to talk about, are we changing components and each plan is unique in the way that the process runs based upon the site selection? Or is it the selection or how you have to build foundations and roads to access it, make it unique?
And you actually, I think, are partly maybe eliminating some of my questions by making the point that I'm trying to make. A request for information, Mr. Moore, is a very different thing than a request for a proposal, correct? for example, and I'll let you obviously have a chance to respond. A request for information is just that, an opportunity to gather information. And in response to a request for information, you may have a CFA, for example, provide information that it generally has about the cost of a facility somewhere as an estimate. In a request for proposal, when you're actually committing, executing a contract, signing an agreement that will basically bind you to a cost, you need a lot more detailed information about what those costs will be and exactly what you're committing to. Would you agree with that?
I would agree they did not have all the information. I believe that the information that they had were not orders of magnitude different than what the basis of their response were.
Okay, you think, is it your experience with requests for informations that the responses you get are execution-ready estimates?
I do not. Therefore, my recommendation were not based upon it being executional.
Okay. Now, it's your recommendation that Duke should have sought statutory relief from CAMA amendments for beneficiation requirements from the General Assembly. Is that correct?
I thought that was one of the options they could have pursued. That is correct.
Okay, and have you reviewed the beneficiation statute which is in the CAMA amendments?
I have.
Okay, and could you please turn to DEC Cross Exhibit 39?
Yes, can you give me a minute? As for some reason, my cross exhibits end at 37. I have 33, 37.
Sure, take your time, Mr. Moore.
I think I can find them directly. If you'll give me just a second.
And I'm happy to give you the statute site too, if you prefer to just look it up online. You just let me know.
I would like to think that this is going to be a simple process. Give me just a second. All righty.
If it helps, Mr. Moore, I mean, what I'm going to ask you, I'm not going to mark this either. I was just going to ask the chair to take judicial notice of it. But I think I'm going to ask you some questions that you're probably going to know just from having read the statute. I'm not going to have you read it. So you want to take that subject to check, and your counsel can obviously jump in if she thinks I misread something.
I'm comfortable with that.
Okay. Now, just Chair Mitchell, because I did introduce it, if we could if we could just take judicial notice of the statute.
The commission will take judicial notice of 130A 309-309.216.
Thank you, Chair Mitchell. Now, can we agree that the General Assembly was very specific regarding the type of beneficiation projects it intended to have constructed in the timetable for that operation? And specifically, Mr. Moore, what I was going to refer you to was the fact that within the statute, it says explicitly that the beneficiation facility must be capable of processing 300,000 tons of ash annually to specifications appropriate for cementous products.
Yeah, and I interpret this to mean 300,000. When you look at these, there's a input into the plant and there's an output on the backside of the plant. I refer to the 300,000 as the output on the product side.
And I think as you indicated, you'd expect to get 300,000 tons out of the plant, correct? So you may have to put more in to get that much out. Is that correct?
I believe the record will show you do have to process more to get this much out.
Now, no later than 24 months after issuance of all necessary permits, the statute provides that the units are to be in operation. Is that your understanding as well?
It says it in paragraph B for sure.
Okay. And can we agree that the statute went into effect before the RFI, was issued by Duke?
Oh, it did. Yes, sir.
Okay, so it's fair to say that the requirements in the statute aren't premised on the RFI estimate submitted by CFA, correct?
Restate that.
Sure, I just want to make clear the RFI response that CFA submitted, that has nothing to do with what the legislature took into account when the General Assembly put in place the statute, correct? Because it came out.
Are you asking me, was this statute available and known at the time that CFA replied to the RFI?
I'm actually asking you the converse of that question, which is, would you agree with me that the RFI was not available to the legislature, the General Assembly, when they created the statute?
I believe this statute was created prior to any response to the RFI.
Thank you.
I believe that the RFI was actually submitted in response to the requirements of this statute.
Thank you. And you'd agree with me that there was no contemplation at the time the statute was put in effect that the contracting will be done with H&M. Is that fair? Kind of follow along to the earlier question?
Yes, sir.
And we can agree that within the statute, there's no mention of cost at all. Is that correct?
Other than the variance authority.
Okay, but variance authority is not in the statute we're reviewing right now, correct?
That's correct. It came out later.
Now, in support of your alternative that the company should have sought relief from CAMA, you reference, believe it, I'm gonna probably get the site wrong, but it's in North Carolina GenStat 62-133.8 I2, which I understand to be the Renewable Energy and Efficiency Portfolio Standards.
Yes, sir.
Okay. And I know you're not a lawyer, but you understand that the Renewable Energy and Efficiency Portfolio Standards statute you reference is not part of CAMA.
Yes, sir. I do realize that.
Okay. So this isn't a law that governs beneficiation projects, correct?
Correct.
Okay. Now, you also suggest that the company should have inquired of DEQ what the consequences would be if Duke did not comply with the beneficiation requirements of CAMA. Is that correct?
Would you please repeat that?
Sure. You also suggest in your testimony or recommend as an alternative that Duke should have inquired of DEQ what the consequences would be if Duke did not comply with the beneficiation requirements of CAMA. Correct.
I believe that I thought that they should have informed DEQ of the excessive cost and sought a variance based upon that.
Okay, so just so I completely understand this, so Duke being fully capable of complying and having taken steps to develop the beneficiation projects that are required by the General Assembly, it's your alternative recommendation that Duke should have just gone to DEQ and asked them, what are you going to do if I choose not to comply with the law?
So I guess this is where I understand that you say Duke is fully capable of complying with the law, but what's happening is by their action, they're making all ratepayers pay for their compliance of the law. They're not paying for it and saying it's taking it out of Duke coffers. They're asking for reimbursement to comply based on ratepayers. So I believe due to the cost of this regulation and the impact it may have to ratepayers, that they could have sought some relief. Yes, sir.
Well, let me ask this question, because I didn't see this in your testimony, Mr. Moore. Do you have any information that the General Assembly did not understand the cost consequences of this statute before they issued it?
Well, only thing I can do is understand what I believe was readily available information. I believe, based on being in the industry, that I believe that the legislature was lobbied for this type of legislation. I believe there was information where this type of technology had existed and what the costs were at other parts. So I believe the best information they had was the information that was provided to them at the time that they were adopting this legislation.
And that's all speculation, isn't it, Mr. Moore?
It is absolutely
I think earlier
speculation.
said you do not know. Okay.
I do not know. It is speculation.
Now, you reviewed the commission's rate case order, or have you reviewed the commission's rate case order in docket E7 sub 1146?
If I recall correctly, I provided testimony in that case, I believe.
Yeah, you did, sir. And in fact, that was the last Duke Energy Carolina's rate case that you testified in. I should have probably identified it that way to make it a little easier in terms of not just giving docket numbers. Have you reviewed that order?
I have. It's been some time since I read it, but I have definitely read it.
And before I ask you this question related to the order, is it your position that statutory requirements and deadlines are just suggestions?
No, I don't believe they're just suggestions.
Okay, thank you. Let me cite you to page 305 of that order, and that's actually DEC exhibit, cross exhibit, I believe, 1.
All right.
Now, if you, I know it's a long order and it's a long page here and it's all single space, but if you would for me, look at the first paragraph at the top.
Of the first page?
Of 305, page 305.
305. Give me a second to get there, please.
Yes, sir. You just let me know when you've gotten there.
Okay. Does it have at the top the ending of a previous paragraph, and then the first complete paragraph starts with witness Moore's proposal?
Exactly, sir. Yes, sir. If you look roughly 7 sentences down, or not sentences, but 7 lines down, there's a sentence that starts with the word the CAMA deadlines.
Yes, sir.
Would you mind reading that for me?
The CAMA deadlines provide the overarching framework by which prudency must be assessed. 2018 DEP rate order, page 185. In addition, witness Kieran noted that
you can keep going if you want to, Mr. Moore, but that's really all I wanted you to read.
Yes, sir.
Yeah. And the order will speak for itself in terms of the other part, but for efficiency, I don't need you to read the whole paragraph.
Yes, sir.
And the same language, and I think you just maybe answered my next question by pointing out the site. So the same language also appears in the Duke Energy Progress Order, correct?
That's correct.
Okay. And would you expect the company did read that order and has acted accordingly by trying to make sure its conduct falls in line with the deadlines required by CAMA?
Sure. Yes, sir.
So let's turn, if we could. Well, let me ask you this question before we turn to confidential. Now, turning to your contention that costs from Buck, Lee, and Cape Fear beneficiation units should have been analogous to costs to Winyon's facility. Have you looked at Ms. Bendarcic's rebuttal testimony in this case?
I have, and again, when you say analogous to Winyon, I believe Winyon is a point in data, but I do not believe, it's an example. I do not believe that I have ever said that it should be, Winyon is a comparable, identical type facility, and it should be used as the basis. I believe what I have said is that Winyon is an actual operating facility that was constructed and is in operation and gives the people that build it a idea of what it will take to build a similar facility that meets the CAMA requirements.
Okay, and it could, in fact, be the basis of CEFA's estimate, correct? In that part of the issue that we're discussing here?
Yes, sir. I believe it is the basis of their estimate.
And did you review Ms. Bendarcic's DEP testimony prior to preparing your testimony today?
My testimony that was filed in February?
Well, not pre-filed. I'm sorry, I should correct that, Mr. Moore. Did you review Ms. Bendarcic's DEP testimony prior to preparing to take the stand today?
I have read Ms. Bendarcic's testimony.
Okay.
Are we saying specifically Duke Energy Carolinas and Duke Energy Progress?
Yes, sir, and the exhibits. I assumed you had read them. I'm just asking that question.
Yes, sir. Yes, sir.
Now, if you could, would you please turn to DEC Cross Exhibit 36?
Excuse me, if you gentlemen can try not to speak over one another, that would be very helpful.
I apologize. That's probably more me than is Mr. Moore.
No problem. Thank you very much.
Okay.
Number 36.
Number 36.
All right, Mr. Marzo, just I missed your direction. Would you point me again to where you were looking?
Sure, Chair Mitchell. I asked the Mr. Moore if he would please turn to Duke Energy Carolinas Exhibit 36.
Would that be DEP Bednarsik Rebuttal Exhibit 8?
Yes, sir. If you have that and that's more handy, that would be the exact same document.
Okay, I believe I have that document available.
Okay, thank you, Mr. Moore. Chair Mitchell, I would like to mark this document as DEC GNM Cross Exhibit number 3.
Okay.
All right, Mr. Marzo, the document will be marked DEC Garrett and Moore Cross-Examination Exhibit number 3.
Now, taking a look at paragraph 4 of this affidavit, which is the affidavit of William R. Fedorka, which was also, as you indicated, provided in response in Bendarsik's rebuttal in Duke Energy Progress. He is the vice president of the CFA group. Is that correct?
That's correct. It's identified here.
Okay. And if you look at paragraph 4 of this document, how many tons of ash per year was the WINYA unit designed to generate?
It says, as originally designed, the WINYA Star was intended to generate 250,000 tons per year of beneficiated fly ash under normal operation. So that would be comparable. That output would be comparable to the CAMA's 300,000 tons per year.
Now, you say comparable, but as you just acknowledged, there's about a 50,000 ton of ash difference per year. And as you suggested earlier, that, in your opinion, is the output needed, correct?
I believe this 250,000 tons stated here is an output that is consistent with the same 300,000 tons as an output referenced in CAMA. I'm not referring to them as being the same number. I'm saying that they both represent what comes out of the final product from the plant.
Okay, and I did not see in your testimony any sort of design detailed analysis as to the impact of cost of going from 250 to 300, correct?
That is correct. I did not.
Now, looking at paragraph 6 of the affidavit, what percentage of ponded versus production ash was the WINYA unit intended to process?
Well, I'm reading this and I said, is originally designed, the WINYA Star specification assumed that 33% of the ash to be processed in the facility would be supplied directly from operations at the WINYA generating station. So I believe that that's referring to production ash from the plant. It never went to an ash basin. And 67% of the ash to be processed in the facility be supplied from impoundments located at the WINYA generation station or elsewhere in the Santee Cooper system. So this is implying 67% would be ponded ash and 33% would be production ash. And again, it's using the term designed. I would like to expand on that if we have some time. And what I would say is, I don't disagree that this is what was designed. Okay. I'm saying that there's other documents that is referenced in my exhibits that talk about what WINYA station is fully capable of. It says in their response to the RFI that we were referring to earlier that WINYA station is fully capable of processing 100% ash supplied from impoundments. And that it can operate at full capacity even when the WINYA generation station is offline.
So are you disagreeing with the affidavit provided by the Mr. Fedorka, who is the vice president at CFA Group? And that
I'm not disagreeing because, excuse me, I'm sorry, I didn't mean to overtalk. Yeah. I'm not disagreeing. This is specifically saying is originally designed. That was the intended. I do not believe that what he says here is contradicting even what CFA said in their response to the RFI. I believe it may have been originally designed, but he's also saying it is fully capable of processing 100% ponded ash, which is also from CEFA.
And it's your opinion that a unit that is designed to the specifications that are listed here by Mr. Fedorka is equivalent to a unit that's designed to process 100% ponded ash? Because that's the design that's required in North Carolina for Duke's unit.
I understand that, but I'm saying that it's not in this affidavit, but it's certainly in the response to the RFI that the Winyah station is fully capable of processing 100% ponded ash.
And I understand that that's your response, but I want to make clear the Winyah station was not designed to process 100% ponded ash, correct?
I think that we're discussing minutia when you talk about design, and I'm not aware, and he didn't make any indication here of what designs would be changed for him to what if it was designed for 100%, that would actually require differences in equipment and such at the plant.
Okay,
and if it was designed, it's fully capable of it.
And you didn't do that type of analysis either, Mr. Moore, correct?
I did not, but I'm just saying, as it says here, doesn't indicate to me that, the design actually changed, because he certainly indicated it is fully capable of doing 100% ponded ash.
Looking at paragraph 8 of the affidavit, do you see the CEFA was able to repurpose significant existing infrastructure, including the storage dome, a loadout silo, truck loadouts, a bag house, gas coolers, a control room, and elements of electrical equipment when building the Winyah Star facility?
I believe that they did use some equipment at that facility that was repurposed and used ultimately for the Star facility. And I believe that, in my opinion, the difference of when they said that, they're saying this is what the Winyah station. So, of course, the Winyah station, the published articles out there say that it was, I don't believe if I say that number, that's confidential, is it?
Well, we're about to go into confidential in a moment. I've got one last question I can ask you, and if you want to reserve that.
I will reserve it without using the numbers, but I'm saying there are published numbers that are out there that are referred in my exhibits of what CEFA indicated the Winyah station cost. Those published articles do not indicate how much of existing infrastructure was utilized and what was, does that refer only to new equipment or repurposed equipment? But I do not believe their response to the RFI was based on the assumption of using repurposed material equipment.
Well, would you agree with me? I know in your testimony you referenced various public articles, but in this case we have the affidavit of Mr. Fedorka from CEFA. Would you agree with me that he's saying that they reuse significant equipment at the Winyah site?
Yes, I would. I would certainly agree that he indicated they used, certain equipment. He certainly did not attempt to put the value of this significant equipment and what it would have cost or what this significant equipment saved versus building it from scratch.
Okay, and just for clarity for the commission's purposes, and I think you just said that Duke's units are entirely new construction, correct?
I agree. Yes, sir.
Okay. Madam Chair Mitchell, at this point, the remainder of my questions will be confidential. Would you like us to transition over?
Mr. Marzo, yes, but I would like to take a break first. So let's do this. We are going to take a 15-minute break for the court reporter. At 10:20, we will join the teleconference line that you all have provided for purposes of continued examination on confidential information. So just to be clear, we will take a break for the court reporter until 10:20. At 10:20, we will go back on the record, but we will be on the teleconference line.
Thank you.
All right, we are in recess until 10:20. All right, Joanne, if you would you give me the signal?
I'm ready.
Okay, perfect. All right, let's go back on the record, please. Mr. Mehta, I do not see Mr. Mehta at this point, but I want to respond to his request this morning regarding DEC witness Leoy. I have consulted with commissioners and commission staff, and we have no questions for Mr. Leoy, so he may be excused from being presented for examination purposes.
Thank you, Chair Mitchell. I'll let him know, and I'm sure he will not be unhappy.
All right, let's proceed. Ms. Yost, with you.
Thank you. Mr. Garrett, I have a few questions for you. If we could refer to what was marked as DEC Garrett and Moore Cross Exhibit 1. And Mr. Marzo, if you could please remind us what which potential cross exhibit this was?
I believe one was, give me 1 second. Yeah, number 1 was 34, cross exhibit 34.
Thank you. And so Mr. Marzo referred you to the first paragraph on page 4 of that document. Do you recall that?
Is this DEC Exhibit 34 Bednarsik rebuttal? I'm not sure of which document you're referring to.
This is DEC, yes, Exhibit 34. So this is the Duke Energy Court-appointed monitor bi-monthly update dated
Okay.
September 14, 2018.
Yes, that's the one I'm on.
All right. And so he had you read from the first paragraph of page 4. Do you recall that?
Yes, I do.
And so can you tell me, is there anything in the second paragraph on that page that would have impacted the progress of the excavation?
The second paragraph says, besides the logistical issues, the site has also faced severe rains over the summer, and recent measurements have revealed that original estimates of total ash did not account for approximately 460,000 tons of ash.
Yeah, so is there anything about that that would have impacted the progress of the excavation by Parsons?
Yes, the severe rains over the summer would have impacted Parsons' progress, certainly when you consider the limits on the discharge available from the site by the permits and the treatment capacity provided by Duke.
Were those factors that were within Parsons' control?
Parsons was not in control of the quantity of wastewater that could be discharged from the site. And Parsons was also not responsible for quantifying the amount of ash that needed to be excavated by the CAMA deadline.
And so was there anything that was done after, subsequent to this date, that would have helped Parsons deal with that water?
Yes. I'll walk you through the pretreatment permit with the city of Eden. This is dated.
And before you get there, let me go ahead and introduce that as an exhibit. And so I would request that what was pre-marked as public staff redirect 57. And this begins, let's see. This is the City of Eden. Is a request for approval of an increase of daily flow. This is a document dated October 23rd, 2018.
Yes, the flow in the original.
And hold on, let me just get, I'm sorry, let me get that marked.
Ms. Yost, could you give us the page number that appears at the bottom of the document?
Yeah, hold on, I have a different copy, I'm afraid. Sure. So the page number appearing on the bottom of the document is 1637.
Ms. Yost, what redirect exhibit was that again?
57. Oh, I'm sorry. Actually, let's see. I'm sorry. It's actually redirect 23. It's also marked as public staff cross 57, but the redirect is 23.
Okay, and can you restate the number at the bottom of the page?
Yes, I apologize. I think I gave the wrong number. It should be in the redirect exhibits 789. And I'll just wait until Chair Mitchell, you signal that you have that document.
All right, I'm not seeing it, Ms. Yost, in the redirect compilations. So can you give me the number of the cross-examination number
Sure.
that was used?
It should be 57 going by the cross numbers. And again, that would be.
Yeah, okay. I
You got it. Okay.
I see it here. All right, so let's go ahead and get this document marked. I'm currently looking at public staff potential hearing exhibits, and it's behind tab number 57.
So at the top, it should say City of Eden.
Yes, that's correct. All right, let's get this one marked.
Okay, I would request that exhibit be marked or identified for the record as Garrett Public Staff, Garrett and Moore, Redirect Exhibit 2.
All right, the document will be marked Public Staff, Garrett and Moore, Redirect Examination, Exhibit number 2.
All right, and Mr. Garrett, can you tell us what the significance of this document is in terms of, what would have allowed Parsons or how it would have impacted Parsons' ability to maintain the excavation rate under the contract?
Well, the original pretreatment permit that was issued allowed for 0.3 million gallons per day to be discharged from the site. The document that you just referred to, dated October of 2018, increased the allowable discharge of this to the city of Eden to 0.6 mgd, doubling the permitted capacity allowed to be discharged to the city. And that the additional dewatering capacity certainly would have helped Parsons' efforts in drying ash, in excavating ash, and landfilling ash.
But at what point in the process did Duke seek this approval to increase the flow?
The City of Eden approval was dated October of 2018, which was after they made the decision to remove Parsons.
Okay. Mr. Marzo asked you about Parsons' sequenced excavation plans and recovery plans that were obtained by the public staff and discovery after your testimony. Do you recall that?
Yes, I do.
Does any of the information contained in those documents change your recommendations in this case?
No, they don't.
Could you explain why, please?
Well, because the recovery plans prepared by Parsons were not based on the increased flow or what subsequently happened later in December of 2018, where Duke Energy was allowed to begin using outfall 002, which would allow them to discharge an additional 1.5 MGD. So Parsons' performance on the project was based on their experience with the limited discharge that was available at the site.
Thank you. And then just one final question. And you can probably do this as a subject to check, but I am going to refer to DEC Exhibit 2. This is the Commission's final order in the 2017 DEP rate case. And I believe it's on page 190 of that order. The Commission makes a disallowance of $9.5 million for contracted disposal costs with waste management. Do you recall that disallowance from the last DEP rate case?
Yes, I do.
And was that made based on your recommendation?
I believe it could have been, yes.
All right, no further questions.
All right, at this point in time, just out of abundance of caution, I'm going to ask the parties if there is any additional cross-examination for these witnesses that does not touch on confidential information or that will not elicit confidential information.
Nothing from the AG's office.
All right, hearing none, we will proceed then to questions by commissioners. And commissioners, I just remind you that we are in public session now. To the extent that you need to ask questions that elicit confidential or that have the potential to elicit confidential information, we will need to return to confidential session. All right, let's begin with Commissioner Brownbland.
No questions.
All right, Commissioner Gray.
No questions at this time. Thank you.
Commissioner Clodfelter. All right, I'm hearing none from Commissioner Clodfelter. Commissioner Duffley.
No questions.
All right, there you are, Commissioner Clodfelter. Just checking in with you one more time. Questions from you?
Madam Chair, I have no questions for either Mr. Moore or Mr. Garrett. Thank you.
Okay, thank you, sir. Commissioner Hughes.
No questions either.
All right, and Commissioner McKissick.
No questions at this time, Madam Chair.
All right, well then at this point, Mr. Garrett and Mr. Moore, we appreciate your testimony. Today, there appears to be nothing further for you. I will entertain motions from council.
Thank you, Chair Mitchell. I move that Mr. Moore's Exhibits 1 through 7 and Mr. Garrett's Exhibits 1 through 21 attached to their pre-filed testimony be admitted into evidence.
All right, Ms. Yost, hearing no objection to that motion, it is allowed.
Thank you. And additionally, I move that confidential public staff Garrett and Moore redirect Exhibit 1 and public staff Garrett and Moore redirect Exhibit 2 be admitted into evidence.
Hearing no objection, that motion is allowed as well.
Thank you.
Chair Mitchell, I would ask that my cross-examination exhibits be moved into the record.
All right, Mr. Marzo, hearing no objection to that motion, it will be allowed. And I would just note for the record that at least one of those exhibits, cross-examination exhibits, is confidential. All right, anything further for these witnesses? All right, hearing none, gentlemen, you may step down. Thank you very much for your testimony today.
Chair Mitchell, this is Diana Downey.
All right, Ms. Downey.
Chair Mitchell, in abundance of caution and to make sure that we're ready, we have 2 motions to excuse pending for Dustin Metz and Jeff Thomas. Just wanted to know the status of those so that we can make sure they're available if needed.
All right, Ms. Downey, we will, I will consult with my colleagues after the conclusion of the hearing today, and we will issue an order forthwith.
Thank you, Chair Mitchell.
All right, public staff, you all may call your next witness.
Chair Mitchell, this is Nadia Laura with the public staff. Our next panel is the Lucas Magnus panel, and no parties have indicated they have cross for this panel. So unless the commission has questions, we would ask that they be excused.
All right, Ms. Lure, I would ask commissioners, any questions from commissioners for these witnesses? For this witness panel. I'm not hearing any of my fellow commissioners indicating any questions. All right. So, Ms. Lure, your witnesses, well, at least Mr. Lucas may be excused. It appears that Mr. Manis is scheduled to appear with Mr. Junis in the panel immediately following this one. So he will not be excused at this point in time.
That's right. Thank you.
All right. So Mr. Lucas may be excused. I'll entertain motions on his testimony and exhibits at this point in time.
Yes, I would move that Mr. Lucas and Mr. Manis's pre-filed joint direct testimony, summary of testimony, and errata sheet be entered into the record as if given orally from the stand, and that their exhibits attached to the pre-filed joint testimony be entered into the record and marked for identification as pre-marked.
All right, hearing no objection, Ms. Lure, to that motion, it will be allowed. All right, public staff may call your next witness panel.
Thank you. The public staff now calls Mr. Junis and Mr. Manis to the stand.
All right, Mr. Junis and Mr. Manis. Mr. Manis, we have now seen you a number of times, but I'm going to go ahead and we're going to get you gentlemen under oath. Would you raise your right hands, please? You affirm testimony you're about to give shall be the truth, the whole truth, and nothing but the truth. All right.
I do.
All right. And Mr. Manis?
I do.
All right. Thank you. Gentlemen, you may proceed, Ms. Lure.
Thank you. Mr. Junis, would you please state your name, business address, and current position for the record?
Yes, my name is Charles Junis. I work at 4030 North Salisbury Street in Raleigh, North Carolina, and I am a utilities engineer with the Public Staff, Water, Sewer, and Telephone Division.
And on February 18th, 2020, did you prepare and cause to be filed testimony consisting of 75 pages, an appendix, and 20 exhibits?
Yes.
And on March 3rd, 2020, did you prepare and cause to be filed corrections to Junus Exhibit 2, as well as corresponding corrections to page 28 of your testimony?
Yes.
Do you have any other changes or corrections to your testimony, appendix, or exhibits?
I do not.
And if you were asked the same questions today, would your answers be the same?
Yes, there would be.
Did you prepare a summary of your testimony?
Yes, I did.
And Chair Mitchell, at this time, I would move that Mr. Junus's testimony and summary of testimony be entered into the record as if given orally from the stand, and that his exhibits be marked for identification as pre-marked.
Hearing no objection to that motion, it is allowed.
And my colleague, Mr. Grantmeyer, will be presenting Mr. Matus.
Good morning. This is William Grantmeyer, Public Staff Attorney. I will be sponsoring Mike Manis, who he has already pre-filed testimony in the consolidated docket. But Mr. Manis, would you please state your name, business address, current position for the record?
Michael C. Manis, 430 North Salisbury Street, Raleigh, North Carolina. I'm Director of the Accounting Division of the Public Staff.
Now, did you cause to be pre-filed on September 9, 2020, your third supplemental testimony consisting of 12 pages of testimony and exhibits 1 and 2?
Yes, I did.
Now, you noticed some corrections to your testimony, and there was a late filed correction, but it was not filed until today. And you would agree that those corrections are not controversial in any way?
I would agree.
Now, other than that, did you file a summary of your testimony?
Yes, I did.
And there was one minor correction to or two minor corrections that were non-controversial?
Yes.
Okay. Now, other than that, would you have any other changes or corrections to your testimony or exhibits?
No, I do not.
And if I were to ask you the same questions today, would your answers be the same?
Yes.
Chair Mitchell, I move at this time that Mr. Manis's third supplemental testimony and the summary of his testimony be entered into the record as if given orally from the stand, and that his third supplemental exhibits be marked for identification as pre-marked.
All right, hearing no objection to that motion, Mr. Grantmeyer, it is allowed.
Chair Mitchell, the witness is available for cross-examination.
All right, we will proceed. Mr. Mehta, you are up.
Chair Mitchell. And I am hearing some feedback. I think it might be from Mr. Grantmeyer, but I'm not sure.
We will get, okay, I'll make sure I mute.
Yeah, it was just like papers rustling. Mr. Manis, I think we'll start with you. In this case, Mr. Manis, the public staff is again proposing a 50-50 sharing between customers and shareholders of even prudently incurred coal ash costs, like it did in the last Duke Energy Carolinas case and like it did in the last Duke Energy Progress case. Is that right?
Yes, for those that are related to the ARO.
So when you say for those related to the ARO, what do you mean by that?
Well, that would be the same costs that we recommended in the last case, the same category. There are costs in this case also that are related to coal ash, but not related to the ARO.
Understood.
So our position here, which has been settled with the company, is a new position for this case.
All right, I understand. When you're talking about the ones not related to the ARO, I guess those are the ones that are called the non-ARO coal costs or something like that. It's the capital costs associated with reconfiguring plants and things of that nature, correct?
Yes, that's correct.
Okay. And I guess to be totally technically accurate, in the last DEC case, the split was 51% that you assigned to the company and its shareholders and 49% that you assigned to customers, correct?
Yes, that's because we try to make things a little administratively simpler, to pick an even number of years and not years and certain number of months. So we try to get as close to 50% as we can. And so that's the reason it was slightly off 51-49 or approximately thereabouts in the last case.
Now, the commission actually rejected the public staff's sharing proposal in both of the preceding cases, the DEC case and the DEP case, correct?
Yes, and they are both still on appeal to the North Carolina Supreme Court.
And in the prior cases, you testified that the 50-50 sharing or 51-49 sharing splits came about simply as a result of the judgment of the public staff, correct?
Yes, that's generally correct. There's significant testimony in the cases which give the reasons for that judgment, but it was a judgmental decision on the part of the public staff.
And in this case, the public staff has again provided a judgmental split, which in your judgment, the appropriate split is 50-50 with respect to even prudently incurred coal ash costs in the ARO.
Yes, well, I guess I would phrase that for only the prudently incurred coal ash costs. For those that we consider unreasonable or imprudently incurred, we've recommended that they be entirely disallowed.
So for example, the costs that Garrett and Moore believe are imprudently incurred, those are removed from the equation off the top. Is that right?
Yes.
And then whatever's left, the public staff does not believe were imprudently incurred, but the public staff advocates that they be split 50-50, correct?
I think Mr. Junis could probably give more detail, but we're not making a conclusion that they were not imprudently incurred. We have just not been able, for various reasons, to develop the evidence of imprudence. But even though we are not making a case for them being imprudently incurred, we still believe that the company has the ultimate responsibility for those costs being too high to be borne by the North Carolina retail ratepayers.
Now, in the recently concluded, I guess recently is probably an elastic term, probably back in February, the commission decided the latest Dominion, North Carolina rate case, correct?
Yes, that's correct. I'll take the date subject to check. You're right. It seems forever.
And in that case, the public staff, the judgment of the public staff was that the proper sharing would be 60-40, with shareholders bearing 40% and customers bearing 60%, correct?
Yes, that's correct.
Well, which one of you can explain to me why Dominion's shareholders get assigned a smaller percentage of coal ash costs than Duke's shareholders?
Well, I can give you a general explanation, and Mr. Junis would have to address the details. I think that the biggest difference between the two cases is the fact that Duke was subject to a criminal complaint. But there's more than that, and I would relay your question to Mr. Junis for further details.
Yes, sir. And that's detailed in my testimony, a comparison of the records that were under consideration by the commission, both in the DENC rate case and then the Duke Energy rate cases. Clearly, there is a difference in that Duke had the federal criminal plea. Duke has a much more considerable record of groundwater violations. And so those are the two key differences. And I'm happy to go into the testimony if necessary.
Sure. Well, let's, Mr. Junis, I'm just looking at page 7 of your testimony. Tell me when you're there.
I'm there. I'm ready.
And you indicate line 5, DEC has accumulated a record of significant environmental violations. Do you see that?
Yes.
And you indicate on line 8, these violations include unauthorized seeps. Do you see that?
That's correct.
Dominion has unauthorized seeps, does it not?
Yes, I believe so.
In fact, Mr. Junis, if you would look at what was previously marked as DEC Exhibit 22 and 23. And Chair Mitchell, I'd like to go ahead and identify these exhibits for the record, and we will call DEC Exhibit 22 DEC Junis Manus Cross-Examination Exhibit 1.
All right, Mr. Mena, just to make sure we're all looking at the same document, will you describe the document for me?
Yes, it is a complaint filed in the United States District Court for the Eastern District of Virginia, with the plaintiffs being the United States of America and the Commonwealth of Virginia, and the defendant being Virginia Electric and Power Company, DBA Dominion Energy.
Okay. Thank you, Mr. Mena. The document will be marked DEC Junis Manus Cross-Examination Exhibit number 1.
And Chair Mitchell, DEC Exhibit 23, if we could have that one marked for identification as DEC Junis Manus Cross-Examination Exhibit number 2, that would be great. And for purposes of the record, this is the consent decree in the case in which Exhibit 1 is the complaint.
All right, the document will be so marked.
And the both documents reflect that each one of them was filed with the Eastern District of Virginia on the same day, March 13th, 2020. And Mr. Junis, if you would look at what we've marked as DEC Junis Manus Cross-Examination Exhibit number 1.
Yes, sir. I have that open.
So on the very first page of the complaint, it's alleged that Dominion had violated the Federal Clean Water Act and a Virginia state statute called the State Water Control Act, correct?
Yes, sir.
And the Federal Clean Water Act allegation relates to violations of Dominion's NPDES permits, correct?
Yes.
And the violation of the State Water Control Act involves specifically seeps, correct?
Yes, sir.
And the complaint further alleges that Dominion had additional violations with respect to release notifications of hazardous substances under the Emergency Planning and Community Right to Know Act and the Superfund law, correct?
Yes, sir. That's under item C.
And Duke Energy Carolina has had no such hazardous substance release notification violations, did it?
I am not familiar with a similar charge against Duke Energy.
Well, does that mean that you think they might have had one and you just don't know about it, or that they didn't have one?
I would say I'm not aware of one. I'm not claiming that I suspect they did or didn't have one.
Well, Mr. Junis, if they had had one, you probably would be aware of it, wouldn't you?
Yes, sir. But like I said, I'm just not aware of one.
And in the consent decree, which is DEC Junis Manus Cross-Examination Exhibit 2, Dominion agreed to pay a civil penalty of $1,400,000, correct?
Are you referring to page 11 of that document?
Yes.
Let me scroll there real quick. Do you know where the total amount is listed? Is that on page 11?
I believe so. Let me go there too.
And what was the amount you stated?
It's on page 11, paragraph 10. Within 30 days after the effective date of this consent decree, defendant, meaning Dominion, shall pay a total of $1,400,000 as a civil penalty to the United States and the Commonwealth of Virginia, correct?
Yes, sir. I see that.
And if you keep scrolling down, there's a number of, I guess, go all the way down to page 15. There's a section called injunctive relief. Do you see that?
Yes, sir.
And in that section, the consent decree, once issued by the court, would require Dominion to do a number of things, correct?
It appears so, but I'm not overly familiar with this document, so I don't know exactly what they were required to do.
Well, you can just scan. The first thing they're required to do is what's called an EMS audit, correct? That's paragraph 24, 25, a few paragraphs down. And an EMS audit is essentially an environmental management audit, correct?
Yes.
And they were going to select an auditor to perform that audit, correct?
Yes.
And on page 17, you can see that that audit was really to investigate management practices at Dominion's power generation business, correct?
Yes, sir.
And if you go on down to page 19, Mr. Junis, Dominion was further ordered to undergo a third-party environmental audit. Do you see that?
Yes, sir. And I would just like to note, as you stated, that these documents were filed in March of 2020, well after the completion of the most recent Dominion Energy rate cases. So this was not in the evidence for consideration by the public staff or the commission.
Well, did the public staff investigate Dominion as to whether or not the factual bases of the complaint and the consent decree were in existence as of the time of the last Dominion case?
We certainly did a thorough investigation. As I said, I'm not overly familiar with these documents, so I'm not sure if who knew what in terms of the actual claims.
Well, if you go back up to page 3, Mr. Junis, of the consent decree. So that would be cross exhibit 2.
Yes, sir.
The last sentence on the page, this is dealing with SEEPs, says, in addition, well, actually, we'll just take a look at the entire paragraph H. You see that? On July 21st, 2017, a Virginia agency identified an area of groundwater seepage along the James River in the vicinity of Dominion's Chesterfield Power Station. Do you see that?
Yes, sir.
And the last sentence says, on May 11th, 2018, Dominion self-reported to the Virginia Department of Environmental Quality its observation of groundwater seepage. Again, in the vicinity of the Chesterfield Power Station, correct?
Yes, sir.
The Dominion rate case that was decided in February of 2020 began when?
I don't recall the exact date, but in 2019.
Somewhere in 2019. July 21st, 2017 is before it began, correct?
Yes, sir. And while Mr. Lucas was the witness in that case, I certainly helped in that investigation. I do not recall seeing information regarding this issue. We rely heavily both on the regulators and the company to provide such information. Like I said, I do not recall seeing this.
Did you ask Dominion about SEEPs?
We certainly asked Dominion about SEEPs, environmental compliance, their groundwater monitoring data. It was exhaustive and very much replicated our investigation of Duke in their prior rate cases.
Well, did they not tell you about these 2 SEEPs?
Without diving into all those records, like I said, I do not recall seeing information regarding these SEEPs.
And if you go on down, I think we were around page 19, go back there.
Okay.
Yeah. Page 19, just above the third-party environmental audit section, the consent decree in paragraph 28 said that the Dominion would complete full implementation of any recommendations of the EMS audit, essentially 9 months after receiving those recommendations, correct?
Yes, sir. And I would just add that this evidence would be appropriately considered in Dominion's next rate case when they continue to seek recovery of coal ash costs.
So, Mr. Junis, is it your testimony then that when you're comparing the environmental records of 2 utilities that the public staff in part regulates that look a lot alike, that somehow just because you don't happen to know something that would factor into an allocation of responsibility that the public staff makes as between those 2 utilities?
Certainly, the public staff and the commission is reliant on the facts that are available in the case. We cannot all of a sudden materialize information that is not given to us either through discovery through the company, which is the primary source. They are supposed to have the burden of proof to justify their costs. And then from regulators as sometimes a double check or as a secondary source. So, and as GS 62-133D states, the commission shall consider all other material facts of record that will enable it to determine what are reasonable and just rates. And that is the basis of our equitable sharing. So we only know what we know, and that's the same for the commission. And I'm not suggesting that information was intentionally hidden, but if that happens, how could we be aware of it if it was never seen?
All right. Well, Mr. Junison, we don't need to go through all of the parts of the injunctive relief, but they go on for pages and pages and pages, do they not?
It appears so. This document is 60 pages. So, but like I said, I've only scanned what we've talked about here.
And if you go back to page 7 of your testimony, Mr. Junis, you also indicate in that numbered paragraph 1 that DEC had groundwater exceedances with respect to the operation of its coal ash basins, correct?
That's correct, sir.
And when you say groundwater exceedances, I assume what you mean is that there were exceedances of the two state North Carolina 2L standards in the groundwater sampled at various points in time. And that's how you come up with an exceedance, correct?
Yes, sir. Those are exceedances both of the standard and background levels, and would therefore be considered a violation as confirmed by the amicus brief in the appeal proceeding.
Now, Mr. Junis, Dominion had groundwater exceedances in connection with its ash basin sites, did it not?
Yes, sir.
You just didn't count as many as you found for Duke, correct?
That's correct. And part of the issue there was some of the historic data with the procedure that those analysis were conducted. It would not be apples to apples comparison.
Mr. Junis, while you were conducting this investigation of Dominion as part of its last rate case, did you consult with the Virginia environmental regulators to see if you could get information from them?
Yes, I believe so.
You believe so, or you know so?
Yes.
And did you not get information from the Virginia environmental regulators as to the number or quantity or frequency of groundwater monitoring evaluations done in connection with Dominion's ash basins?
We certainly, I apologize. My phone rang and I thought I hung it up. So that was silenced. I apologize to the chair and the commission and all parties. Regarding your question of Dominion's, holy moly, sorry. I'm going to unplug the thing. Sorry. Mr. Meadow, do you mind repeating the question?
I think it was more or less, did you, in the course of your investigation of the Dominion in its prior rate case, did you ask the Virginia environmental regulatory authorities for information that the Virginia environmental regulatory authorities would have had on Dominion's ash basins, and in particular, groundwater exceedances in connection with those ash basins?
Yeah, so I mean, in the Dominion, in that testimony, in Mr. Lucas' testimony, we lay out the observed exceedances. So I'm not sure. There is historic data that, again, is not comparable to today's standard.
Well, do you know how far along Dominion was in its investigation of groundwater at its ash basins in comparison to how far along Duke Energy Carolinas was in connection with its investigation of ash basins?
Yes, sir. So both Dominion and Duke are subject to the CCR rule. So they had detection and assessment monitoring requirements, and that's where we got a considerable amount of groundwater exceedances. And they have state laws comparable to North Carolina, while different. And so we did look at that and accumulate as much information as we could.
In fact, while you say comparable, Mr. Junis, they're comparable in the sense that they say thou shalt not pollute the groundwater, but they're quite different in terms of the rigor and robustness of the standards that relate to the thou shalt not pollute groundwater direction, correct?
Yes, sir. I did not mean to insinuate that the programs were the same, but only that they could be compared.
So let me get this straight then, Mr. Junis. Duke Energy Carolinas has seeps. Dominion has seeps, correct?
Yes, sir.
Duke Energy Carolinas had groundwater exceedances, and Dominion had groundwater exceedances, correct?
Yes, sir.
And at least the federal complaint about Dominion indicates that Dominion was also fined in connection with NPDES permit violations and violations of hazardous waste reporting issues, correct?
Yes, sir. But as we said, that consent decree was filed here in March of 2020 after the commission's decision in the Dominion rate case. And as I stated, this evidence would be duly considered in its next rate case.
So if I'm understanding it, and basically I think Mr. Junis, I believe that the public staff in the Dominion case expressed a fair amount of frustration that in its investigation of Dominion, that it was not able to obtain a number of documents that it had requested, correct?
We did express frustration. We even, at one point, there was an agreement pertaining to some of the data and its availability and the appropriateness of its comparison to present day data.
So, Mr. Junis, is Duke Energy Carolinas being penalized by the public staff because it has better records and it's operating under an environmental regime that is a whole lot more robust than the one in Virginia?
I would not characterize it as being penalized. As I said, that these bodies can only make a decision based on the evidence before them.
Well, you're applying a different standard. The judgment of the public staff is that Dominion has a better environmental record than Duke Energy Carolinas. Is that basically correct?
Yes, based on the available evidence, there is some adjustment for environmental compliance, and Mr. Manus can attribute this, that the equitable sharing is based, a majority of it is based on the magnitude of the costs and the comparable treatment of canceled nuclear plants and manufactured gas plants. But then there is also a component tied to environmental costs.
Well, the sharing percentage that you use for Dominion has nothing to do with the magnitude of the cost, does it?
It absolutely does, and I'm happy for Mr. Manus to expand on that.
You mean the difference between the sharing percentage, 60-40 for Dominion, 50-50 for Duke Energy Carolinas, has something to do with the magnitude of the costs?
Oh, no, I misunderstood the question. I'm sorry. No, that difference is not tied to magnitude.
Okay. And you mentioned the criminal proceedings with respect to Duke Energy Carolinas. And that is certainly a distinction between Duke Energy Carolinas and Dominion. But the criminal proceeding didn't, in fact, there was no guilty plea, for example, with respect to a violation of the state 2L standards, was there?
No, there was not.
In fact, the criminal process and proceeding occurred as a result of or flowed from the Dan River incident, which was there but for the grace of God, go I, any utility would be subject to some of that, that kind of scrutiny if it happened to them, correct?
The plea agreement did not only cover the 39,000 tons of coal ash that was released into the Dan River.
Thank you for reminding us of the tonnage, Mr. Junis. I really appreciate that. Yes, it did not only deal with that, but that was the impetus behind it, correct?
Certainly that would prompt further scrutiny.
And if Dominion, by misfortune, had a pipe break under one of its coal ash basins and had 39,000 tons of coal ash flow into the Roanoke River, for example, they might have the same problem, right?
I would not agree with that characterization of misfortune, as there was negligence shown in that case.
Well, in the case of Dominion, if they had a pipe break in the same way that the Dan River pond had a pipe break, would that also not be negligence?
Depending on the circumstances, I'm not going to speculate on a hypothetical, but I will agree that such an event would warrant additional scrutiny.
Now, Mr. Junis, you mentioned also, and actually, Chair Mitchell, I'm about to run into a completely, not completely different, but a different subject. I don't know if you want, it's a couple of minutes before 1. If you want to stop here, that'd be fine. It will take me longer than a couple of minutes to go through the next subject.
All right, Mr. Mehta, let's go ahead and call it a day. We will go off the record. We will be in recess until 9 o'clock on Monday morning. Thank you very much.